Welcome, dear friends. This is Agroheritage course. We are in the second semester. Today we will talk about intellectual property and agroheritage relationships. First of all, we will try to make some definitions on intellectual property. To the best of our knowledge, the intellectual depth of humans makes things different from other organisms. Human develops ideas, and from these ideas, he or she produces some tangible and intangible products, and we solve problems. Some of these products are inventions, artistic works like musical or other artistic works, knowledge, and literature. The creative work is not easy, and it requires an effort and investment like money and labor. Historically, a reward system has been developed to recognize these works as property of their creators, so that creators would be motivated, which result in an economic and social improvements in the society. More or less similar legal systems have been established to regulate and to counterbalance the use of the intellectual property by creators and by the society. So creators have exclusive rights, especially commercial rights, to their creation in balance with the common good. All these systems are collected under the intellectual property rights. We can say them shortly IP rights. These are mainly copyrights, which are given to literature and artistic works, and industrial property rights, which are mainly patents for inventions, trademarks. This is a sign distinguishing one's good and services from others. Industrial designs, these are ornamental or aesthetic aspect of an article. Geographical indications, these are signs distinguishing goods of a specific geographical origin. Trade secrets, confidential information which may be sold or licensing, and plant breeder rights. Commercial use of goods, services, and information created by these intellectual property rights are regulated by national laws, but these laws are shaped according to international treaties, because it is related to gaining commercial profit. The main objective of these regulations is to prevent commercial use of this property without obtaining the permission from the original owner. The protection of the majority of IP rights is territorial, which means that the protection is granted within a country. To extend these rights to other countries, one should apply them directly to these countries via special international equipments. The most widely participated international organization related to intellectual property rights is WIPO, World Intellectual Property Organization. There are many treaties administered by WIPO. Another organization which concerns international intellectual property and trade-related issues is WTO, or WTO, World Trade Organization. The WTO agreement on trade-related aspects of intellectual property rights is the main legal framework that shapes IP regulations of the WTO member states, that is, nearly all countries of the world. Another related organization for IP-related issues is the International Union for the Protection of New Varieties of Plants, UPO, which is directly related to intellectual property rights of plant breeders. The European Union also regulates intellectual property rights as a framework for their member states and associated countries. Two important regulations are EU regulation on quality schemes for agricultural products and foodstuffs for geographical indications, and the European Patent Convention, which is EPC in brief. Intellectual property rights are divided in two groups. One group is copyright related or artistic works related intellectual property rights, and the other one is industrial property rights. These industrial property rights have more impact on agro-heritage matters. Let's look them briefly. First of all, a patent is an exclusive right granted to an inventor for his or her invention, which can be a product or a process. To give an invention a patent, the invention should be new. That means not disclosed to the public. It should have an inventive step. It means not obvious to the skilled person, and should be applicable in the industry of any field, including agriculture. And the invention should also be disclosed sufficiently clear and complete. The patent applications are published after a certain time before the decision of granting or not granting. So the inventor discloses his or her information on the invention to the public. In return, an exclusive right, that is patents, usually 20 years. After 20 years, the rights will be expired and the invention becomes public property. There are also some general exceptions for patentability by law and treaties due to ethical reasons, for example, giving a human embryo a patent, or legal reasons to prevent dual protection or concurrent protection, or to prevent granting discoveries, for example, a mathematical theory. For example, plant and animal varieties are not patentable according to EPC, European Patent Convention, Article 53, but a new process, also products obtained from this process, related to them may be patentable. So, plant varieties are protected usually under plant breeders' rights. Plant breeder rights are also exclusive rights granted to the breeder for a new plant variety. Plant variety is described as a more precisely defined group of plants selected from within a species with a common set of characteristics. A breeder shall be granted where the plant variety is new, that is, it is not sold or disposed to date or to public, distinct, clearly distinguishable from any other variety in particular features, uniform, sufficiently homogeneous in particular features when propagated, and stability, stable in particular features at each cycle of propagation. Now we come to the third group of intellectual property rights related to agriculture and agro-heritage. Geographical indications. These are signs show that a product has qualities or a reputation due to its specific geographical origin. Granting a product name as geographical indication promotes the product and related traditional knowledge. The ones having right to use geographical indication prevent others from the use of the sign in their products if they do not obey the standards given in the description of geographical indication. Geographical indications also differ from other IP rights. It is a collective right since all the producers in that geographical region have the right to use the protected GI indication as long as they comply to the specific characteristics of the product. This means that geographical indication or GI rights are community rights, whereas the other IP rights are exclusive rights. They are granted to a specific applicant, that is the inventor, breeder, or creator. What does these IP topics have to do with the agricultural heritage? First of all, geographical indications or GI rights are designed to promote communities that still produce traditional products. The right to use GI sign on their traditional product and prevention of selling unreal products under that GI name will be useful to differentiate from the real product from the unreal ones, so the consumer can understand and pay to the right product. By distinguishing GI products with the sign will protect the reputation of the real product. In addition, GI registry covers the quality check procedures of the registered product in a periodic manner. The producers who do not obey the technical specification of the traditional product or who are not one of the producers in the geographical region that is described in the GI disclosure are prevented to sell the product under GI sign. We can learn more on GI issues by investigating EU regulation on quality schemes, agricultural products and foodstuffs. According to this regulation, GI signs are divided in these classes. The first class is protected designation of origin, food and wine, product names that have the strongest links to the place in which they are made. Example is Malatya kayısısı. According to the same EU regulation, the second geographical indication class is protected geographical indications, food and wine. These are product names where a particular quality, reputation, or other characteristic is essentially attributable to its geographical origin. An example for this class is Antep baklavası. The third group is geographical indications for spirits, drinks, name of a spirit drink originating in a region where reputation or other characteristics are essentially attributable to its geographical origin. For example, Uzo of Taraz is an example. The fourth class is traditional specialty guaranteed. Product name highlighting traditional aspects rather than a specific geographical area. An example is pizza napoletana. As you see, EU system focuses mainly on food and spirits. However, many countries have a larger scope of protection. For example, according to Turkish industrial property law, many kinds of products, including agricultural products, food, mining products, handicrafts, and other industrial products, can be protected under GI or geographical indication. In the previous lectures and interviews related to traditional food and textile, we gave you many examples for geographical indication having products. As we have seen, geographical indications is given to traditional products. On the other hand, patents and plant breeder rights do not cover traditional products or processes. As mentioned before, they are given to new inventions or new plant varieties. How do we decide they are new? According to 54 of the European Patent Convention, prior art or state of the art is everything made available to the public by means of written or oral descriptions, by use or in other way, before the date of filing of a patent application. So to grant a patent, a search on the state of the art related to the subject of the invention is performed to decide on novelty. The plant breeder rights also require novelty, but a little bit differently. However, sometimes inventions which are not novel can be patented if the patent search do not turn a relevant information for the particular invention. Therefore, all patent applications are published before the decision for granting or not granting, usually 16 months after application, so that public can see and can appeal. Before raising awareness on biological resources and traditional knowledge in underdeveloped or developing countries, these resources were used freely by industrial cultures. The route from the traditional knowledge to patent could not be traced, and profits were received only by the industrial cultures. Balasubramanian described this process as biopiracy, means misappropriation of traditional knowledge with an intention to gain patent protection over that knowledge. There are cases where traditional knowledge was filed as a patent application and cancelled by appeals. For example, turmeric patent. Turmeric is a plant used as healing of wounds for ages in India, and neem patent. Neem is also a plant used for curing dermatological diseases in humans and also as fungicide for plants, and this is again has been used for ages in India. So the documentation of traditional knowledge, of course, including agro-heritage, is crucial. Another aspect of the patents and plant breeder rights is that they may be based on agro-heritage related to traditional knowledge or its elements. Although something is not novel, this does not mean that it emerged freely from prior art. It may use that knowledge to go further for new inventions. Actually, every technological development and discoveries in science uses the previous knowledge as a base to go one step further. Similarly, many inventions made in agriculture used already existing ones for a start. For example, breeding of new varieties of plants or transferring, combining of genes in another organisms make a new application of existing knowledge. As said before, many biological resources and related traditional knowledge were used directly or as a basis for new inventions. Such an example is Basmati patent. Basmati rice is a traditional rice grown in northern India and Pakistan. This patent covers altered Basmati lines. As indicated in Balasubramanian, Basmati has been grown and protected by Indian and Pakistani farmers for ages, but the main economic profit goes to the patent holder. It is obvious that agricultural diversity should be conserved for the future food security. A very well-known example is the Great Famine in Ireland in 1940s due to the potato blight caused by the fungus Phytophthora infestans. Another historical example that proves this fact is the efforts to develop stripe rust resistant wheat and barley cultivars by using a plant introduction from Turkey in United States. Strap rust is a fungal disease caused by fungus Puccinia stiriformis. These and the above-mentioned IP-related conflicts led to the introduction of some concepts related to legal issues and signing of new treaties. One of them is Convention of Biological Diversity. This convention aims the conservation of biological diversity, the sustainable use of its components, and fair and equitable sharing of the benefits arising out of the utilization of genetic resources, including by appropriate access to the genetic resources and by appropriate transfer of relevant techniques. This is the Article 1 given the purpose of the CBD. Article 8J of this convention states that traditional knowledge shall be protected, maintained, promoted, and equitable sharing of the benefits shall be encouraged by national laws. Article 15 of the same convention states that states have sovereign rights over their natural resources, and access to genetic resources shall be mutually agreed and subject to prior informed consent of the contracting party providing such resources. Further articles describe the obligations of contracting parties related to the technology transfer of the knowledge, including patent rights, the right from these resources, and equitable sharing of the benefits. Based on this convention, two further protocols were established to regulate these issues. Cartagena Protocol on Biosafety, which aims to ensure the safe handling, transport, and use of living modified organisms, and the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from their utilization. Other international mechanisms such as the Food and Agricultural Organization (FAO) and World Intellectual Property Organization (WIPO) have similar initiations for proposing balance in between IP rights and genetic resources and related traditional knowledge. The International Treaty on Plant Genetic Resources for Food and Agriculture aims to establish a global system to provide farmers, plant breeders, and scientists to access and to benefit from plant genetic materials. This treaty is administered by FAO. A multilateral system was established considering 64 crops to be shared among these parties as provider and as receiver by terms of Standard Material Transfer Agreement. You can investigate the Standard Agreement on the web page. If IP rights, for example patents, are received on the new materials based on the transferred material, the receiver should transfer some benefits to the benefit sharing fund of this treaty. Besides FAO, WIPO has been working on this issue more than 20 years. As indicated in the web page of the WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, the committee undertakes text-based negotiations to finalize an agreement on an international legal instrument or instruments for the protection of traditional knowledge, traditional cultural expressions, and genetic resources. no agreement has been reached up to date. In summary, agroheritage constitutes the main part of the genetic resources and traditional knowledge in the world. Despite the above-mentioned efforts, still there are no effective international agreements with enforcement mechanisms on prior informed consent, disclosure of geographical resource, fair and equitable sharing of the benefits, or appropriate transfer of relevant technologies for the use of resources, genetic resources, and traditional knowledge important for agriculture. As a result, the deep conflict between industrialization and conservation of any kind of diversity, that is biodiversity, social or cultural diversity, complicates resolving these difficulties. Dear friends, thank you very much for listening. Have a good day.